New tonight, more than 42,000 arrests were made in the last fiscal year involving kids. That's according to the Florida Department of Juvenile Justice. State Attorney for Orange-Osceola counties, Monique Worrell, joins us live tonight to talk about this. Monique, thank you so much for joining us, Mr. Worrell. Your office obviously has gone toe-to-toe with state officials and others in law enforcement concerning issues involving juvenile justice. What are your biggest concerns right now?
Right now, my biggest concerns are that our juvenile justice system is wholly inadequate to deal with violent crime committed by children. And unfortunately, although we've seen a reduction in arrests involving juvenile over the last decade, what we haven't seen is a reduction in felonies. So although the overall arrest rate has gone down, the felonies committed by children has continued at the same pace or even gone higher. And our juvenile commitment programs are just not adequate to deal with what's happening in the system. So when we hear juvenile reform, we think of something that's going to be softer in dealing with children who commit violent offenses. That's not what this is at all. What we're requesting is that we have a juvenile system that has more teeth to deal with felony and violent behavior committed by children.
Your office has mentioned what they call the missing middle in juvenile justice. Can you tell us more about that and how that would play a role with the task force that you created?
Absolutely. So we launched the Missing Middle Task Force in April of this year, and it's focused on the missing middle. What is when children commit crime and they're kept in the juvenile system, what we've seen is that routinely the maximum amount of time that they're staying in commitment programs is 18 months. Well, for a child who commits a very violent offense, 18 months is simply not enough to accomplish the goal of the juvenile justice system, which is rehabilitation. So if I don't believe that's enough and I want them to be in a place for a longer period of that, my only other option is to direct file or transfer that case to adult court, where they're facing maximum penalties of up to 25 years in the Department of Corrections, which also is not an adequate response to dealing with a child who commits a crime. So that missing middle exists between 18 months and that 25-year sentence. What can we do with children who are committing these serious offenses to help rehabilitate them, which is the goal by statute of the juvenile system.
So is that the maximum, the 18 months? And what are you asking the state to do? Is it a lack of resources to house these children? Is that the problem?
Right. So we've talked a lot about that as well. What I'm asking the state to do is change the law surrounding juvenile commitment and allow judges to impose a minimum time that a child needs to stay in a commitment program before they're released. That's what our legislation is requesting the legislator to change the law surrounding.
Let me pause you really quickly. You said a program. People hear that and they think, is this kid at home and required to go to meetings and something like that? That's not what this is. This is a program inside of lockup.
So maximum risk programs are like prisons. They are prisons for children, right? And we can have a debate over whether or not it should or shouldn't be. That's another discussion for another day. But when I say program, these are commitment programs, and maximum risk programs are secure facilities that do not allow children to leave those facilities during the time period in which they have been committed. Now, you've asked me, is 18 months the maximum? There isn't a maximum because, as I've mentioned, the goal for the juvenile system is rehabilitation. So the maximum is as long as it takes for a child to be rehabilitated. What we're seeing, however, is that the longest time that they're being kept in is about 18 months, and that is solely up to the Department of Juvenile Justice to determine. The state attorney's office does not have a say-so in that. The court doesn't even have a say-so in that. It is strictly the Department of Juvenile Justice who makes a determination when they believe the child can be released. We believe that that decision is being motivated on a lack of resources. The fact that they have children that are sitting in detention centers waiting for these commitment beds, and in order to turn over the bed quickly enough, they will release a child before they have in fact been rehabilitated.
Last thing, we've got to make it quick. Obviously, there's a line between accountability and making sure that the public stays safe and also rehabilitation of that child. It's a case-by-case situation, but how much is it going to take people coming together to find the answer to that missing middle?
I think that it is going to take a community effort, and that's why we've launched the task force, so that we can bring the community together so that we can focus on fixing that missing middle for public safety.
State Attorney for Orange and Osceola counties, Monique Worrell, thank you so much for joining us.
Thanks for having me.